Ladies and gentlemen, good morning. I'm happy to see you all here at this panel as a moderator. My name is Cornelia Topf. I'm a partner in the Gleiss Lutz company. And our today's topic is strategies of defense for public takeover offers, and I will introduce our speakers. Our first speaker is Natalia Drebeskina. She's a partner in the Debevoise and Plimpton firm in Moscow office. To my right is Philip Chevalier. He's a partner in the Travers Smith firm from London. Alan Metzeler, partner of Stiebe firm from the Netherlands. To my right is Yuri Bortnikov, partner of the Vegas Legs firm from Moscow, and Martin Hitzer, who is also a partner in Gleiss Lutz from Düsseldorf. And I guess we will continue in English.
A presentation right away. And start with a brief introduction before we come to our first case study as kind of a warm-up. So today we will be focusing on public takeover offers, which means we will be dealing with publicly listed corporations. Shares in publicly listed corporations can be freely traded on the market, and this again makes those kind of corporations particularly vulnerable to takeover offers. Takeover offers are not hostile by nature as such, so they can be very valuable to shareholders, in particular when the bidder offers to the shareholders a high premium on the share price, which is higher than the stock market. And they can also be valuable to the company as such, in particular in case that the bidder's strategy with the target company actually fits to the concept of the company itself. But on the other hand, of course, takeover offers in any event endanger the independency of the company, and they could also endanger the further existence of the corporation. And what we want to discuss at the beginning of our session is actually what is a hostile takeover offer and what exactly makes a takeover offer hostile. And I wanted to start with Phil on this and raise this question to you. How would you define a hostile takeover bid?
Thank you very much, Cornelia. I think in the UK market, one can look at a full spectrum of approaches to takeover offers. We have clearly consensual offers where, for example, mergers where two companies approach each other and a normal consensual negotiation takes place to establish a recommended transaction. But when we talk about unsolicited offers or unsolicited approaches, we are really thinking about the scenario where a quoted company is approached by a potential takeover suitor in the context of an offer being made for that company. And 9 times out of 10, that will start a negotiation process that will result in a recommended offer for the target company. When we talk about hostile offers in the UK, we really mean the scenario where the target company board at no point, or maybe very late in the process, recommends the offer from the bidder. And there may be a number of reasons why it doesn't want to recommend the offer. The obvious one, of course, is price, the value of the offer, whether the offer or the offer price represents a significantly large premium to the prevailing market price to justify a recommendation. But also there are a number of other factors that we might take into account, for example, strategic issues around the target company, even employee and workforce related issues in certain instances, and also potentially social issues. But I think if the price is right, a number of those other issues can be overcome. But I think the main scenario is where the bidder simply approaches, is rebuffed by the target board, and the bidder then decides to proceed with a hostile offer or a takeover battle in a scenario where it has no recommendation, no engagement with the target company, so no access to due diligence, and no consensual process.
Thanks a lot. Is this the same approach in the Netherlands, that you say it's hostile if you don't have the consent of the board of the target company?
It's fairly similar. I think we would define a hostile offer as an offer that is eventually made without a prospect of a recommendation by the management board and the supervisory board by the time the offer will be formally made. We have a fairly long period between the announcement of an offer and the actual launching of the offer through the publication of an offering circular. It's only at that point in time that the boards formally need to issue their opinion on the offer, neither recommended or not recommended. We have seen a number of cases where offers start perhaps without much support from management, but where during the process between the announcement of the offer and the final launch of the offer, some form of compromise is reached, and where eventually the offer is recommended. Good example of that, I think, is the famous ABN AMRO case, where ABN AMRO received a hostile offer from a consortium of banks after it had announced a merger with Barclays. At the end of the day, the boards did not recommend either offer, but took a neutral position in the final phase on both offers, and basically left the decision to the shareholders. I think in the Netherlands, the concept of the duties of directors is slightly different, I think, from the UK. We are more applying what we refer to as the Rhineland model, which entails that a company is not primarily managed for the shareholders, but also for the other stakeholders, particularly employees, but also creditors, other trade parties, and more there is a sense that perhaps the general interest also plays a role in the boards of duty, in the duty of boards. So typically a board of a Dutch company would certainly look at the price, but there have been quite a few cases where the hostility against an offer or against a proposed offer was based on other things than price. For instance, situations where there was an expectation that the bidder would tear the company apart, or perhaps be a threat to the employment of employees, etc. Having said that, hostile takeovers, I mean a takeover where a bidder actually pursues an offer in spite of resistance from management, are still very rare in our country, but there is a sense that we may perhaps see more of that in the near future.
Martin, is there a trend to hostile takeover bids, or what are you currently seeing on the market?
Certainly we've seen very few in the beginning of the takeover era, which was in Germany the early 2000s. From all offers we have seen in that time, less than 10% were unsolicited. What we see these days is a trend to unsolicited offers, and it's all about price. It's kind of what Philip and Allard already pointed out, that bidders try to get a foot into the door of the target company by offering a very low consideration and not really a premium for the control stake. In Germany, we call these low ball offers. It's something we can maybe discuss a little later. And we've just analyzed the past 2 years, and significantly amount of the offers we see are so-called low ball offers, and therefore considered unfriendly by management. It's something around 50% of the offers these days, so that's considerable. Yeah.
50% is quite a lot. So how's this in the UK? Can you say that?
In terms of hostility and lowballing, well, I think if one looks at genuinely hostile offers where the bidder proceeds to make its offer where it doesn't have a recommendation, they are a very small minority. What you'll typically see is an unsolicited approach will result in a recommendation at a certain point. So the percentage of genuinely hostile offers would be under 5%, I would estimate.
Okay. Alad will report later on our first case study why the percentage rate of hostile bids in the Netherlands is even lower then. We thought, given the fact that we understand that in Russia, unsolicited takeover bids are pretty seldom, we should start with an introduction on how the situation is legally, but also in practice on the Russian market. And for this purpose, I wanted to hand over to Natalia.
Thank you, Cornelia, and good afternoon, everyone. It would be fair to say that, as Cornelia mentioned, in Russia there are essentially no precedent of hostile offers. And we're not talking about hostile transactions or type of offers that constitute, let's say, a raider type of acquisition of control. So that's the term to which hostile offer and hostile transactions typically relate. But offers as such, unsolicited, that's something that's not oftenly used, or rather, given that the takeover statute was introduced just several years ago, it's still a process that's used in a slightly different context in Russia. One of the reasons for that is that most Russian public companies have a controlling shareholder, so it's not companies with a large free float, as is in some other jurisdictions, but rather having one or two shareholders that can effectively exercise control, which means that hostile transactions are often exercised by putting pressure or negotiating initial acquisition of the controlling stake with the major shareholders. In Russia, it's pretty, and I'm sure that most of you are aware that acquisition of certain stakes grants the acquirer certain rights. And a person can go up to 5% without receiving any approvals from the regulators. Going above 25% will require approval either from the anti-monopoly authorities, or if the company is strategic, then depending on what type of the company that is, may also require approval of the government. However, up to 25% stake may be acquired without any need to get any approvals from any of the regulators. And that stake does give significant rights. Up to 29.99 stake, so just slightly below 30%, can be acquired without the need to do a mandatory offer or any offer to the shareholders. And as opposed to other jurisdictions, that's how the transactions are often structured. As I mentioned, acquisition of this certain percentage does give a significant right to the shareholder. So getting a 25% stake will give the shareholder right to request not just documents of the company which are open to all the shareholders, but also accounting documents of the company. So essentially get a significant amount of information about the target if the shareholder were to proceed with further acquisition. 25% is also a blocking stake, so essentially gives the right to block a number of important transactions on the company level, including amendments to the charter, major transactions, any reorganizations, so really major decisions. It also gives ability to exercise other rights which are linked to lower thresholds, like right to convene a general shareholders meeting, provide items to the agenda of the general shareholders meeting, demand an audit of the company. So a shareholder acquiring this stake in a private transaction can essentially acquire significant rights and, can enforce them, thus causing the company to deliver documents and really force its policy over the company. One other reason for no precedence of hostile takeovers, hostile bids on the Russian ground is that Russian law generally is structured differently, and it does not as such recognize or distinguish between solicited and unsolicited bids, and that's something that we'll discuss. Basically, most and all bids in Russia that we've seen are unsolicited, because the board of the company, unlike, for example, in the UK, is not involved in agreeing the offer before the offer is actually made. So you would not see these types of transactions in Russia. So the board of the company gets a say on the offer and gets a say to recommend or not recommend the offer only when the offer is actually received by the company. Moreover, very often the bidders would be very reluctant to approach the boards because that would constitute an inside information. So even though a confidentiality agreement could be entered into between the target and the bidder, but it's still unclear how those would work on Russian grounds. So the bidders tend not to communicate with the board in order not to really get into this gray situation. Therefore, the company's board typically gets involved in the process only when the offer is out there. So, and then the board has a right to have a say as to whether it finds the offer acceptable for the company, whether it recommends or not recommends it, but generally this recommendation does not have any specific consequences, so it does not affect the way the offer is made. It typically, whether the recommendation is neutral or negative, it will not affect the pricing of the offer, it will not affect the manner of conduct of the offer, something that could be reached or changed in other jurisdictions when the bid is solicited and discussed with the board. There are no specific regulations or protections for the target of the shareholders, including minority shareholders, like poison pills used in the US, or a requirement by the regulators, as some of the procedures in other jurisdictions, to make the offer once a formal announcement of the intention of the offer has been leaked within a certain period of time, or refuse to make an offer, so we don't have that requirements in Russia. And the concepts of competing offers, so where, for example, a hostile bid could potentially come in, has never been used. So there were no actual competing offers in respect of the Russian companies, and they serve a slightly different purpose. So they could be used primarily to distract the initial offer. As I mentioned, Russian law envisages or allows for a very few defensive measures, and generally none are explicitly envisaged. So no poison pill, no put up or shut up, so requirement either to make an offer or to withdraw from the offer process, and the prohibition to make an offer for a certain period of time, like 6 months. One of the potential defense strategies that may be used and was used by some of the companies and could be used is acquisition of shares by a subsidiary, which is something yet not prohibited, and vote in those shares. Whether the new reform of the civil code will introduce amendments limited that right, it's yet unknown, because the initial drafts did include these amendments, but that's at least one of the options that could be available to the company as a defense strategy to the company and the management. Russian corporate law continues to develop with the amendments to the civil code, amendments to the Russian joint stock companies law. Takeover regulations continue to develop. There's been a broadly discussed and not straightforward draft of the order of the high arbitrage courts on these matters. Then a draft law by the Ministry of Finance introducing amendments governing takeover regulations. So we'll definitely see further amendments, and it would be very important for the Russian regulators and lawmakers to take into account international standards and experience of other jurisdictions in order to ensure that both minority shareholders and the company are protected in case of potential hostile acquisition scenarios.
Thanks, Natalia. So if there are actually no unsolicited bids currently on the Russian market, what about the Russians going abroad? Yuri, are there any examples where Russian investors go abroad and launch a hostile takeover bid for companies outside Russia?
Yes, if I may, I will give 2 examples of Russian-owned companies doing hostile bids outside of Russia. And the first example is actually dated back to 2007. These old good days before global financial crisis. I don't know if it's still legitimate to refer to that time. But in any case, Russian major company Norilsk Nickel, in expanding its global ambitions outside of Russia, was considering acquisition of Canadian publicly traded company, Lion Ore. And the first offer actually was made, public offer was made by a Swiss competitor of this company, which was called Extrata. And this offer was accepted by the board of Canadian company. Following this acceptance, Norilsk Nickel made another offer, alternative offer for increased price. And the board of Canadian company decided after certain thinking process that it shall accept this offer and revoked its previous acceptance. And another good example of how many tensions or how much is at stake in this type of dealings, Extrata made another offer, which was again higher in the price. And the board again accepted this offer, even though it had to take a commitment with respect to breakup fee. And there was a lot of speculation whether Norilsk Nickel will come up with a new offer or not. The shares of the company raised in their price substantially in this process, and eventually Norilsk Nickel made an offer which the board could not refuse. And in general, it was about $6 billion US, and finally, Extrata decided to pull out of the process, and Norilsk Nickel was a successful bidder. And this is a good example of how competitive offers can be made by two strategic investors, actually, in this case. And this was an example how the offers were accepted but then revoked by the board of the company. And another illustration from this case is probably that the board made a really good deal out of this process by achieving great shareholder value, as a result of this process, and really negotiating a good price or achieving a good price for the business. And the second example refers to quite early period, quite a later period, which was already after the crisis. And the difference with the first case is that in the first example, the reason for making the bid was expansion of the business. The economy was growing. In the second case, it was a reverse situation. Markets were down, and basically a lot of companies were in a vulnerable situation because their assets were underestimated. And this was a case
and the market price was low then, presumably?
Yes, exactly. And in the second case, it was a case of Russian developer whose shares were traded in London Stock Exchange called RGI International. And this is a story, quite emotional story, quite, so to say, if you want to put a certain human touch to this type of relationship, it's a story of two individuals bidding with each other, and then the third, either white knight or black knight, it depends on how you judge, came to the case and actually got everything. But in this story, the owner of this company, Mr. Kuzinets, who actually started this business, and the business was development of luxury residential buildings in Ostozhenka area of Moscow, he actually owned a 40% stake in this company, and the rest was traded in the market and held by several other minority shareholders. And this company was quite successful in the 90s, but then following financial crisis, it was in need of financial resources, and it had to accept an offer from outside investor, a company called Synergy Classic Limited, held by Mr. Shura. So basically, 20% stake in this company was sold to Mr. Shura. As soon as Mr. Shura and his company became the shareholders in this company, the conflict between shareholders had started, following which Mr. Shura made several offers, public offers, to the shareholders of the company to acquire the shares. And the company was still controlled, belonged to Mr. Kuzinets' company called Des Holding, and the board, which was fully controlled by majority shareholder, actually refused both offers, claiming that the offers were untransparent and that the offers were not made to all shareholders of the company. And in a desperate attempt to get control over the company, there was a third offer in which actually Synergy Classic Limited proposed that it just get not the shares but the jewelry assets, so to say, which is a retail shopping center Tsvetnoy in Moscow City, in return for the shares. This offer was rejected as well. And then this is a good also example of various techniques which were used by the parties in the course of this bidding process. Several litigation cases had started in UK courts, in Guernsey courts, and some other jurisdictions. In some cases, it was a success for majority shareholder. In other cases, it was success for minority shareholder. Also, public relations campaign firms were retained by both parties, and there was a substantial influence or substantial negotiation or discussion with other shareholders as to how to proceed with these bidding offers. And the offer which was made, one of our colleagues in the panel made the remark that at the end it's all about prices when it comes to public offers. Here we have a Russian, so to say, story of bidding, of public bidding, and this is a good example that here not the price was the main issue, because the offers which were made by this minority shareholder were made with substantial premium. They were rejected, and later on, after some time, in 2012, the settlement was reached between these two shareholders, but then the third shareholder came, the third bidder came, who was not a shareholder yet, and proposed a price which was substantially lower than the price initially offered on these public offers. And for whatever reason, majority shareholder decided to agree and sold his stake in addition, together with some minority shareholders. And then following 6 months period, the remaining shareholder, Mr. Shura, also sold his stake. So eventually the control of the whole company was transferred to a third investor, which is actually Globox, a bank which is a subsidiary of Внешэкономбанк. So that's another example of how Russian companies do in public bids abroad. And basically I fully agree with Natalia that in Russia the stock market is still a little bit so to say, not ready for this type of endeavors. Our legislation maybe is not up to date, but we are in a good direction. Court practice may be also not coming to kind of need to improve substantially in this areas, but at least these examples show that Russian corporations are ready to participate in this process, and they actually do outside of Russia. Thank you.
The tool seems to be well known on the market. Indeed. So we now come to a very interesting case with a specific defense tool that is available in the Netherlands, and I would like Allard to take over and to tell us something about the anti-takeover foundations.
Yes, thank you very much, Cornelia. We actually saw a hostile offer developing in the Netherlands last year. As I mentioned earlier, this is one of the rare occasions where a real hostile offer unfolded. It involved KPN. KPN is the former Dutch national telephone and postal company, which was privatized in the late 90s and then split. And eventually KPN, the telecoms, the Dutch telephone operator, was floated on the stock exchange by the Dutch government, and over time became a purely publicly held company. It was very successful in the beginning, in the dot-com boom times of the early 2000s. I remember that KPN's shares stood at more than 70 euros. Today they are like, I think, 250. And in mid-2012, the KPN share price was approximately 8 euros, which represented a significant recovery from less than, I think, 150 a couple of years before. And then Mr. Slim, or rather America Mobile, which is a very large Mexican-based international telecoms company, and where Mr. Carlos Slim, who apparently is the richest or one of the richest persons in the world, holds a controlling interest, made a partial offer for KPN. That in itself was quite a novel development. Our takeovers code does provide the possibility of making a partial offer, i.e. where a party extends an offer to the shareholders of a company not to acquire 100% of the company, but to acquire a percentage below 30%. It has to be below 30% because above 30% mandatory offer provisions would apply, so it's technically possible to make an offer up to 20.9%. And this is what AMX did. They made an offer for €8 per share, but only for 29.6% of the shares, or maybe 20.8% of the shares. That already was an offer which met with hostility on the part of the KPN board. They were unhappy of getting a very large shareholder on board, and whereas previously the company had been owned by a very widespread shareholders. But eventually they came to a compromise with America Mobile and entered into a strategic agreement with them, allowing them to hold the 20.8%, or in fact accepting that AMX had 20.8%, and AMX had the right to appoint 2 members in the non-executive board of KPN. Then subsequently the share price of KPN went into decline, as was the case for a lot of telecom companies in Europe. They had all overpaid very much for a certain telecom license in the past and had to make very high write-offs on that. So the share price declined to approximately €2, beginning of €2. And then last year, in August 2013, AMX made a hostile offer for 51% of KPN. So that, I suppose, is what Martin referred to as being a low-ball offer. This offer was clearly directed at getting complete control of KPN without having to pay for 100% of the company, but rather for just 51% of the company. That in itself was also unprecedented. In that sense, Mr. Slim did a lot of things that were unprecedented in our takeover arena, because an offer where you indicate that you will accept the offer if as low as 51% of the shares are tendered is quite unusual. This, of course, does not mean that a bidder who makes an offer would not have to accept the shares that are tendered over 51%, but the offer was at, I think, 250, just maybe 10 cents, or it was a very low premium, so the offer was just above the current share price, and in combination with an offer threshold of 51%, that signified that the objective of America Mobile was rather not to get 100% of the company, but a much lower percentage at a lower price. The board of KPN very much resisted the offer on its merits, but also they very much took the line that it is out of line in the Netherlands to make an hostile offer, that the correct procedure for an offer is to engage in discussions with management and to work out a compromise, particularly on what we refer to as non-financial governance, i.e. agreements that the bidder accepts, restrictions that the bidder accepts in terms of how to deal with the company after the takeover has been completed, in terms of respecting the company's integrity, on how its strategy will be pursued, preserving employment, etc., etc. Non-financial governance are typically an element always of friendly takeovers, and where at the end of the day an agreement is worked out between the bidder and the company. We refer to that as a merger protocol, and which basically sets forth all these agreements, and in sometimes even a third party is specially created to monitor the enforcement of those agreements. But here Mr. Slim did not do that, so he made a hostile offer, and this was also connected to a very important transaction on the calendar of KPN. KPN was about to sell a very large German subsidiary to Telefonica, a 5 billion transaction, which needed shareholder approval, and where they also feared that America Mobile might actually vote against that transaction, because America Mobile had expressed in the past that they were not in favor of that transaction. So there were 2 threats for KPN. One, the hostile offer as such, and second, that the Mexicans might frustrate the sale of the German subsidiary to Telefonica. What then happened is that the KPN Protection Foundation, which is the foundation that Cornelia already referred to, quite a few Dutch listed companies have a friendly foundation in place, which is formally an independent orphaned institution. It doesn't have shareholders, it doesn't have a constituency, it's a foundation, a stichting, technically, if you like, a charitable institution which has no assets of its own, which will hold an option over a large number of preference shares in a company, preference shares that have a very low financial value, maybe a few euro cents, but do carry a vote similar as the ordinary shares. So this allows these institutions to actually build up quite a significant stake in a company, up to 50% at a relatively low price. These foundations are usually governed by a board of trustees where you would typically find former Dutch CEO, sometimes a retired or semi-retired lawyer, and who then take a view as to whether a hostile offer is or is not in the interest of the company. In this case, the foundation acted quite successfully. It exercised the option that it had. It also made clear that it was very skeptical about the intentions of AMX, and at the end of the day, AMX withdrew its offer, and they stated as the reason for that, indeed, the interference of the foundation. AMX withdrew, which means they were then liable to the put up or shut up regime, which means they couldn't come back for another 6 months. And the foundation then gave back its preference shares to the company, and which were then withdrawn. So this was an example where a protection foundation actually worked. And although most companies have these foundations, they are typically like your fire hose. You see them on the wall, the red round fire hoses, they are there, but they are actually rarely used. But this time it was used, and it was used successfully, and this has very much again focused attention on these foundations. Most companies have them, but they are in fact quite sleepy institutions that normally don't really do anything. If you read through the annual accounts of a company, you will find some reference to the existence of a foundation. But other than that, it is all very much sort of in the small print of a company, if you like. We have seen a couple of examples in the recent past where these foundations were used not only to discourage a potential hostile bidder, but also to prevent activist shareholders from taking control of a company. We had 2 cases that also went to court, and where hedge funds tried to dismiss the management of a large listed company, and where the foundation exercised the option and then used its voting rights to block these attempts. Both cases went to court, because typically when these foundations come into play, you will see that particularly activist shareholders take them to court to challenge the exercise of this whole arrangement. AMX, by the way, did not do that. They withdrew from the KPN offer without going to court, so we will never know how this would have ended had they taken it to court. Now, these foundations are quite interesting. I don't think there is any other jurisdiction where they exist. I think in some other jurisdictions they couldn't exist because for company law reasons or public offer reasons, the structure wouldn't be allowed. But the structure is in fact a very straightforward structure based on Dutch company law. Under Dutch company law, a company can, of course, issue shares, always by a mandate from its shareholders, but it can also issue options, rights to take up shares, and that's the basis for all these foundations. At some time in the past, usually quite long ago, in many cases in the 80s or 90s, the shareholders of listed companies have approved that the management board would have the right to grant options to third parties, and the articles of association of the company would provide for preference shares that have a very low value. For instance, in the KPN case, an ordinary share of KPN on the stock exchange costs, $2.50, but the value of preference shares is only like maybe 26 cents or even lower. So it means that with a relatively small investment, it's possible to buy a lot of shares. these foundations typically have a financing arrangement in place with the bank, which would allow them to draw on necessary finance to pay up for these preference shares. In the case of KPN, the total cost for the foundation to pay up the preference shares was approximately 250 million euros, which of course is a substantial sum, but if you realize that that gave them the right to vote half of the company's shares with a market cap of more than 8 billion, it already demonstrates the disproportion between voting right and financial right. And in some other companies, the disproportion is even larger because it very much depends on the share price of the company on the stock exchange, which, for instance, another company that used this ASMI, its shares are 30 euro in the stock exchange, but its preference shares are only 4 cents. And if the foundation takes them, they only have to pay up 25%. So that means they basically buy a vote, or they get a vote for a price of 1 euro cent, whereas an ordinary shareholder who would have to buy a common share would need to pay 30 euros to get one vote. In the past, these foundations were not so independent perhaps as today. Usually you would see 1 or 2 members of the company's board also being on the board of the foundation. And it was also very common for companies to provide or at least give a guarantee for the finance that the foundation needs to exercise these rights. That's all changed in the past years. Nowadays, these foundations are truly independent in the sense that they do not depend on the company in order to finance the exercise of the option. At the same time, it's fair to say that you would typically see on the board of these foundations individuals who are not. You would see very few representatives of hedge funds, for example, on these boards. You typically see, as I mentioned, former CEOs, board members, senior figures, in the Dutch business community, basically individuals who are expected to be somewhat sympathetic to the concept of the independence of a company, particularly if it is an iconic company like KPN or some other companies. So in practice, I think the foundation was, in this case, extremely effective, and it has certainly led to a view that these foundations are a factor to reckon with. Also, because there were a number of court cases where the foundations were somewhat skeptically approached by the courts. There was perhaps some doubt about that, but I think since the KPN case, there is certainly the belief that these foundations can be very effective and that it would be very unwise for a hostile bidder to actually approach a Dutch company that has this foundation in place unless there was a fair expectation that a hostile approach would turn into a friendly approach. What was quite interesting in the situation with KPN is that the board members of the foundation were very much involved in the negotiations with the Mexicans, and were very much part of the whole process that eventually led to KPN saying no to the offer and America Mobil withdrawing. So potential hostile bidders on Dutch companies should certainly check whether a foundation is in place, I think, and think twice before they move forward, without having assurances, the offer will eventually turn into a friendly offer.
Thanks a lot, Alain. This actually means that as soon as you have an anti-takeover foundation in place, a Dutch company is actually safe with respect to any hostile takeover attempts. Are there similar corporate structures in place in other countries which can make a company takeover proof? Martin, how's that on the German market?
Well, first of all, I'm still amazed about the structure with the foundation in the Netherlands, because in Germany that for sure wouldn't work for several reasons. And I also ask myself why a shareholder would approve a foundation like this, because at least in capital market theory, a takeover offer per se is something positive for the shareholders, right? Because it increases the share price. There is something like a competition for control, which should be, in theory, beneficial to everyone.
Well, shareholders would never approve it if you would ask them today.
Yeah.
But what you see typically, for instance, in the Netherlands, there are now two big flotation, or in fact 3 big flotations expected. One is the insurance arm of ING, which is being floated. That's actually a private flotation. But there, the shareholders have agreed to this structure prior to the flotation. But of course, prior to the flotation, the shareholder is one party. And with the government floating ABN AMRO and probably also ASR, which is another large insurance company, exactly the same thing will happen. So this is in place before the company actually hits the IPO, if you like.
Which in turn then should lead to the company never getting a stock market price as big as they could, right? Because
well, this is the question, whether there is a Dutch discount because of the existence of the foundation. The debate on that has been going on for at least as long as I am a practicing lawyer, and I think it's still, without a firm conclusion.
Which leads me to your question, Claudia, Cornelia, if I may. The corporate structures we see in Germany that are takeover-proof are actively chosen by shareholders. You could go into a partnership based on shares, which you do pre-floating, and no shareholder would opt on it later, because again, it's something for a family-owned public company that is beneficial, but not probably for the other shareholders. You could also issue preference shares with no voting rights, but with a higher economical right. Again, good for the shareholders that hold the ordinary shares, but not good for anybody else. So all these preemptive measures that you can put in place always come at a price, and the price is, from the view of the outside shareholder, the company is limiting itself when it comes to the potential market capitalization it could achieve. So, these structures have to be viewed with care. You can implement them if there's certain interests, but they don't suit any corporation out there. That's, I think, the bottom line.
But it seems to be relevant then what the purpose of the IPO actually is. Is it just to get fresh money into the company, or to do an exit, to create an exit scenario also for the shareholder at this point in time? Because if I understand you correctly, then a shareholder who actually intends to exit the company would not set up this kind of structure, because then at the same time this would make his exit less probable or less attractive for a potential bidder then.
It's very true. Those companies we see go to the stock market that are being brought there by private equity investors, for example, they would go for the most takeover-friendly regime you could possibly think of, while the companies that are being brought to the capital market, not fully but only partially by families who seek fresh money or access to the capital markets, they would opt, for example, for a partnership based on shares, which basically is takeover-proven structure. That's true.
So how's that in the UK then, Phil?
I would say it's broadly similar to the German position in the UK. We don't have the ability to have a reactive foundation in place in the way that you do in the Netherlands. And if you like, protective measures through share capital structures and options, for example, are extremely rare. I think the only times we see them these days are in relation to some formerly privatized entities where the government retained a golden share, particularly for strategic assets that were privatized. And also some other strategic regulated industries, for example, television and media, where the government requires the ability to retain some control. But in the context of, if you like, a normal commercial scenario, takeover defense measures enshrined in the capital of a company in that way are almost unheard of. And I think there are similar reasons for that. The institutional investor community in the UK will not accept any if you like, limitations on the ability of the company to be taken over for exactly the reasons that Martin's articulated. Similarly, the regulatory regime discourages any sort of limitations on trading or transferability of shares, any non-equivalence of voting rights. So you will not see any companies coming to the IPO market now or being listed that have any of these types of structures in place.
And is there anything else that a board can do in advance of a potential bid?
Well, in the UK market, there are limited things that a board can do in anticipation, and I think we have to distinguish, and we will come on to how a board can react when it receives a takeover offer. But we need to distinguish the scenario of defence planning before the event in that way. We do occasionally see what you would call poison pills in the terms of contractual arrangements, so change of control provisions in joint ventures and financing arrangements. But again, those are not that common, and I think the principal reason again is the duty of a director of a listed company or any company in the United Kingdom to promote the success of the company for the benefit of its members, which means it has to be a fairly fundamental requirement on the part of the counterparty to the joint venture that there be change of control consent in there. And it's a debate we find ourselves having reasonably regularly with listed company clients who are thinking about joint ventures or other significant material contracts where a counterparty is proposing a change of control regime as to whether it's appropriate for those to be included in view of directors' duties. But beyond that, if you like, measures that form part of the company's constitution or governance are very unusual in the UK market these days.
Yuri?
Sorry. So basically, I fully agree with Philip that some kind of a pre-advanced, well-developed plan, defensive plan for takeover shall be thought through. And this is explained also by actual situation that we have, that the bidders are in fact quite experienced and well-prepared subjects, so to say, of commercial relations. So some of them are prepared their bidding strategies for years, and they think about various, pros and cons, and they are well prepared when they make the bid. And as soon as they make the bid, the target immediately is under substantial pressure because the clock starts ticking. And of course, the advantage, there's a huge advantage of having the advanced strategy of defense against such bid if it's needed. But there is another comment which can be made that, as you, Cornelia, has mentioned, there are some situations when owners of the company think, okay, if they go public, the idea is that to get financing and not to really sell the business. Some owners think that after they go public, after a certain time, they will exit from the business. I think businessman mentality sometimes work different way. Like there is a recent statement by Mr. Vekselberg, one of Russian oligarchs. He gave a big interview, and he was asked about potential sale of one of his really valued asset. And he said, well, I'm a businessman. If I'm offered a good price, I always will sell it. So basically, the idea is that such plan of defense against hostile takeover shall be designed in any case, because even though the exit strategy is not planned from the beginning, the offer might be really attractive, and then all this poison pills or any other defense can actually reduce the price. And maybe in selection of these measures, the preference shall be given to those measures which do not really affect the price and which will not decrease the price. For instance, one of the examples and one of the opinion which exists is that maybe a well-developed and long-term business plan shall be elaborated and announced by the target, so that whenever there is a bid which is made, the board, the shareholders can always use it as a basis for determining whether this bid is actually something which they want to pursue, or it's in contrast to their long-term plan. And if it's in contrast, then it will be easier to reject it. Another measure which can be used is profiling of potential investors long time before actually, the bid will be made. And thinking of these investors, maybe having certain contacts or negotiations with them, just in case there is a hostile bid, some other bids can be triggered, and as a result, there might be a better value and more opportunities which will exist for shareholders and for the target.
You mean then lining up the white knights already beforehand?
Well, to the extent possible, of course, depending on the industry, but at least to understand who can be the potential investors, to understand their business, to understand the circumstances in which they can acquire, they can be interested in acquisition. So to have this profiling exercise a long time in advance or before the bid is made.
Martin, if there are defense means in existence and have been put in place by the board, how I, as a bidder who has no access to the books and records of the company, can find out whether such kind of defense scheme is in place. So is there any disclosure requirement for change of control provisions and stuff like that?
To a certain extent. In Germany, at least, you have to disclose everything that's relevant for takeover offers in your annual yearly document, as long as those provisions are not bound by secrecy obligations. And if you structure your change of control clauses, if you want to use them that way correctly, then you will always put them under a secrecy obligation, a non-disclosure obligation. Then you can't disclose them in your yearly document because they're considered business secrets. So. But the other means, I mean, for example, in Germany, what never happens, but theoretically, possibly, you go to your general assembly, to your shareholders, and ask them to increase your capital in case a takeover offer will be launched as a preemptive measure. That you would have, obviously, to disclose because that's a public resolution, right?
And have you seen this in practice?
No, because shareholders don't like it. And even board members don't like it because it taints the company as a potential takeover target. So no CEO wants to think about, oh, I'm going to be taken over. What am I going to do against it? It's sort of a, it's also a reputational issue they have on the market. So no, it's been possible for 10 years, and there has not been one case in practice where the board would actually ask shareholders for preventive resolutions of any sort.
Alad, how do I find out that there is an anti-takeover foundation in place? Is there a disclosure requirement for this?
Not as such, but it will be disclosed because any interest in a company above 3%, be it in the form of shares or options, must be registered with our regulatory authority. So if you check that register, you will easily see that there is a large potential shareholder. And apart from that, it's usual for companies to report on it in their annual accounts. And this dates back from a long time ago when the stock exchange actually had rules on this. Those rules no longer apply. But in practice, they are still observed.
Phil, if I do a public due diligence on a UK target, would I find out whether those kind of change of control provisions are in place?
I think the answer there is you may or you may not. There would be no express requirement to disclose them as a specific takeover defensive measure. But you would certainly, if you were doing a hostile takeover offer of a UK company, look at all of its annual reports, all of its historic announcements in relation to material transactions that it's entered into. And I would have thought any material arrangement, be it JV, financing, commercial contract, that really moves the needle in terms of its share price will have been publicly announced, and the key terms of that ought to have been included in that announcement. So to the extent it's above a certain level of materiality, you should always, with a little bit of targeted diligence work, be able to find out what the broad terms are.
Okay, so, yeah, Martin?
An interesting point with the due diligence in public companies as such, and you could do probably a panel on that itself, because again, in capital market theory, it's what Philip points out, everything you should know to make an offer for the company should be in the public domain. And the question of doing due diligence is also, again, a question, how does the board position itself? You have a preferred bidder, he is able to do due diligence, another bidder comes, wants to do due diligence, is considered hostile, is not getting access to the books. Is that equal treatment? Is there anything material behind the bars? It's a very interesting question, and I believe the publication requirements should be in a way that any bidder is able to do a bid, to structure a bid on the basis of the public available information, in theory. In practice, we see a lot of things where that doesn't work.
There are always judgments taken as to what the level of disclosure ought to be and whether something is sufficiently material. So it may be that looked at in the broader context, something may not be disclosed. Right.
So we come to the Hochtief case now, which is also in this regard interesting, because Hochtief obviously had a couple of those kind of change of control provisions in place with respect to their joint venture participations in international airport business. Has this been known on the market, Martin? Do you know that?
As much as we know, no, it hasn't been known. Hochtief is an interesting example because that was a company that thought itself safe from all harm because it had an anchor shareholder, which also is, considered a preventive measure. Get yourself an anchor shareholder who has a significant minority stake in Germany. If you have 25%, you have a qualified minority. You can block any basic resolutions in the General Assembly. So that's very important. And if you have a shareholder who's willing to keep that stake and be happy with it, that is basically making you takeover proof as well. So in this case, this specific shareholder in Hochtief, which was Spanish corporation ACS, one of the world's largest construction companies, held this stake for 3 years and promised to never increase it. And as promises go these days, at some point, the Spaniards were interested in getting more than just the 25%, so they bought another 4.9%, reaching just barely 30%, which in Germany is the control threshold where you have to launch a mandatory offer. So when they acquired the additional 4.9%, they said, okay, this is it, and we don't want anything more, which sounds already a bit fishy, because if you have 25%, why do you need 29%? But anyway, this promise was in the market, and then unsolicited and surprising to Hochtief, the Spaniards offered an exchange of 8 shares in ACS against 1 share in Hochtief, and wanted to acquire control of Hochtief. And one thing in Germany that is very particular is once you have this one offer succeed, once you go over the 30% threshold, no matter how limited your stake is after that, you don't have to do another mandatory offer at any time. You're pretty much free after a 12-month discretionary period to buy additional shares on the stock market from other shareholders. So if you have the patience, you do a low ball offer again, an offer with a minimum price, you get 30% plus shares, and then you're free to basically start buying into the company at your own discretion. And this is what apparently ACS's strategy was back then. So Hochtief had to look into, and this offer was considered hostile for many reasons. The employees said it was hostile because they feared a restructuring. The politicians said it was hostile because they feared German engineering know-how would go to Spain. The management thought it was hostile because they were fearing they would lose their jobs, which they eventually did. The shareholders said it was hostile because the price was bad. So everybody was really against this offer for a variety of reasons. And Hochtief did what they could do in that situation. They called a General Assembly, which would delay the offer. They increased their capital by 10% and gave that 10% stake to Qatar to get another shareholder and dilute the ACS stake. Again, they argued this is not to frustrate the offer because that would not be in the interest of the shareholders. This is to secure project work in Qatar. This is why we have to give the Qataris this 10% stake. They threatened to sell some of their crown jewels, and that was the Hochtief concession business with the airports and some joint ventures. Problem was that sale process was not ready to go and took too long to actually put these assets on the market. And again, it's what Julie said, once the clock is ticking, you don't have that much time from the target company's perspective. And last but not least, they also had a public listed subsidiary, Leighton, Australian construction company, the biggest Australian actually there was. And it was tried to convince the Australian authorities to make ACS also bid for Leighton, which the whole overall money that ACS would have to put onto the market would have been more than what they could have afforded. So despite all these efforts, and I think this was one of the fiercest takeover battles we had seen in Germany since Vodafone and Mannesmann in 2000, it ended up that ACS just got barely enough shares to go over the 30% threshold, and now they're free to basically increase their stake. By now, this is 2 years ago, they have 59%. They're not yet in the qualified majority, which is at 75% in Germany, but they are comfortably controlling the boards by now, supervisory board and management board, and pretty much taking their influence over the supervisory board into the management. And this is something in Germany that's being discussed now, that we need additional offer obligations after an offer a bidder has made a 30% plus threshold and is starting to acquire more shares. There has to be another offer obligation to give the outstanding shareholders part of the takeover premium.
So how did ACS respond to the capital increase that was done by Hochtief, where Qatar acquired a certain stake and thereby diluted even ACS stake?
They responded in three ways. First of all, they threatened to ask the Financial Supervisory Authority to look into this capital increase to see if it was a forbidden, frustrating measure, which they just threatened because it was evident that would not be very successful. They increased their offer price by 1 share, so they actually went from 8-to-1 exchange ratio to 9-to-1, which is marginal. But they also approached a friendly shareholder in ACS that also had a stake in Hochtief, an American hedge fund called Southeastern, and were able to acquire 2 million shares from those guys, which kind of counteracted on the dilution effect. So they struggled, but in the end, with a little more money on the table and this stake from Southeastern, they were able to make the 30% threshold. Interestingly enough, it could have been acting in concert, again, a totally different subject between Southeastern and ACS, which would have obliged Southeastern to make an offer for Hochtief as well. That was scrutinized by the Financial Supervisor Authority, but that you know, as always, these things don't lead anywhere, and in the end, ACS succeeded.
Do we know what Qatar's motivation was to participate in this capital increase and to acquire a stake in a company that is actually subject to a pending takeover offer?
Well, I like to believe they were hoping to get the company that is building the soccer stadiums for the World Championship in 2022 and have control over that. But it was probably also a financial interest. Yeah.
Okay. Yeah, we take this as an example to discuss in more detail which potential repressive defense measures could be taken in a concrete takeover scenario, meaning when the bid has already been announced and the bidder has shown up and the situation has turned into a hostile situation. And if you start with one of the potential measures, which is the sale of crown jewels, then I would like to ask Alard whether he has ever seen something like this.
No. Generally, the general view is that poison pills would not work if they have been specifically set up to frustrate an offer for the reason that it would be difficult for a board to justify entering into an agreement with consequences that actually would have a negative effect on the company itself solely for the purpose of avoiding an offer. So the view is that these would probably not work, and we haven't really seen them. This doesn't mean that a company that enters into a very important agreement for a reason would probably want to have a change of control clause in the agreement as a potential deterrent to any hostile takeover situation. And there have been situations where I know bidders have actually not pursued an offer because a particular potential target was heavily dependent on certain joint ventures with change of control clauses, and where there was a sense that those might be triggered and actually also enforced in the case of a hostile offer. So it can be a useful deterrent, I think, in practice, but only if it coincides with, you know, a real economic interest of the company to enter into a certain contract. So it's not like in the US, where apparently a company is relatively free to conditionally sell an asset on the condition that a hostile takeover is made, etc. That we don't have that.
So Phil, have ever crown jewels been sold in the UK except by the Queen?
I think the position in the UK is broadly similar to the Netherlands. You have the same issue around directors' duties and can you really, in good conscience and in the best interest of the company, sell a material business or the crown jewels simply as a defensive measure. It would have to be part of a broader strategic initiative to enable the directors to satisfy themselves that they weren't breaching their statutory duties. But the other limb, which is going to be relevant to many of these different potential defensive measures once you've received a takeover approach, is the regime we have which prevents a target company taking frustrating action once a takeover is in contemplation. So the steps that a board can take reactively are very heavily monitored by our takeover regulator, and a number of specific actions, disposals of assets, issues of shares, grants of options, entering into material contracts outside the ordinary course of business, key, if you like, defensive measures are all expressly identified as frustrating action. And if you wanted to undertake any of those actions, having received a takeover offer or an approach, you would need to get the consent of the regulator to do it, but also the approval of the shareholders in a general meeting of the target company. So the practical reality is, for those two reasons, crown jewels disposals are extremely rare, and I struggle to think of an example in recent memory.
What about a Pac-Man defense, or what actually is a Pac-Man defense?
Well, the Pac-Man defense is one of those defenses we talk about and seldom see. The Pac-Man defense is when the target company turns round and decides to make an offer for the bidder the hostile bidder that's approached it. We have seen a couple of attempted Pac-Man defences in the UK. The last one I can think of, which is Wolverhampton and Dudley and Marston, failed spectacularly, and the Pac-Man, if you like, was taken over by the original suitor. But I think they are more, in the UK market, more theoretical than perhaps White Knights and White Squires and those other types of defences.
We come back to the White Knights in a minute. Maybe one step before on the Pac-Man defense, is there any other example in Germany or in the Netherlands?
Well, Germany has seen one that's quite famous. That's the Volkswagen-Porsche transaction, right? Where Porsche was actually the smaller part trying to take over Volkswagen, and when that didn't go anywhere, Volkswagen turned around and took over Porsche. So that's not a classical Pac-Man defense because the situation was a little bit different. But here you have a situation where the original bidder didn't succeed with his bid and was eventually taken over by the former target company. So there's one prominent example, yeah.
Natalia, is there anything you have in mind?
Yes, I wanted to comment on the Russian side. On the sale of crown jewels, we are aware of at least one instance when the company was actually considering such measure as a defense, but ultimately opted not to do it, and largely for the same reasons as we discussed, because that's, apart from everything else, it's also timing. And once you come to an agreement on pricing, then there come corporate approvals. And if we are in a situation when the deal is done by a shareholder acquiring privately a significant stake, then such shareholder can have a significant representation on the board, and essentially under Russian law, if that's a really major transaction, it will need approval, unanimous approval of the board or a shareholder vote, again by qualified majority, which will mean that the transaction will likely not be approved. So very often the target just does not have time to do what it would probably could do in order to effect the sale of a significant asset, even if the price was right and the directors were comfortable that the transaction is not to the detriment of the company. And again, what we have also seen done on the market is acquisition of the shares of the company by a subsidiary, even by way of tender offer. It depends on the structure of the company, but this block of shares, since it could be voted, and it could be voted, for example, by management with proper corporate governance in place to explain the position for the voting, then this does give some leverage to the company to effect certain resolutions.
Yeah. I would like to take up this point that you mentioned on the board composition. So if the bidder already has a stake in the company, it's not unusual that the bidder has a certain representative at the board of the company, which means in a takeover situation, this representative has also access to all information that will be discussed at the board level, also in context of the potential defense against the bidder's bid. So is there any possibility to exclude this member from access to information? Allard, how is this in the Netherlands?
Well, we have a good example of that because America Mobile had 2 members on the supervisory board of KPN. And typically in a takeover situation, the supervisory board has a very important and additional duty to oversee the whole process and make sure that all stakeholder interests are, approached and assessed in a balanced way, particularly if management itself has perhaps other interests in a certain situation. I think in a KPN situation, the 2 Mexican gentlemen were advised to take the position that they had a conflict and should not participate in deliberations of the board on the America Mobile takeover, and that view was accepted. Whether formally board members have a conflict of interest if they are also a manager of the party who makes the bid is actually not. There's no clear-cut answer to that, but I think in practice, and certainly this was the case in the KPN case, the compromised board members temporarily sort of suspended themselves from participating in the board on this subject. And I think personally that is also the right approach.
But what if they don't go voluntarily?
Well, then you have a problem. Houston, we have a problem. Because you can't dismiss members of the supervisory board in a large regime company like KPN. The board is appointed for 4-year periods, and they cannot be dismissed unless there is basically an application of the board itself to dismiss a member for gross misconduct or what have you, or if the shareholders dismiss the board in its entirety. So. That would be a problem. I suspect if that were the case, then probably the other board members would agree among themselves to perhaps decide at the very last moment to hold the meeting a little bit earlier and just overlook the fact that they have to inform perhaps the other board members too. I mean, there are certain well-known tactics, of course, to exclude people you don't like to be in one room with.
So you have a conference call then beforehand with only limited members then. How did Hochtief play with this?
Well, Hochtief formed this, well, they had already several members from ACS in their supervisory board because of the 25% ACS owned prior to the bid, and it was actually 3 members. So Hochtief formed a special committee in the supervisory board just for the takeover situation. It's something the supervisory board is free to do, and excluded all members from ACS being part of this committee because of a conflict of interest. And that's actually a perfectly legal, proper way to do it. That's state of the art. That's what you would do. Yeah.
And again, how did ACS respond?
Well, they were protesting, obviously, but they were excluded from the committee, and to their own best interest, really. They couldn't have voted on any of these measures anyway. Yeah.
Phil, coming back to the White Knight defense mean then again, do you know any White Knights, and what actually makes a knight to a White Knight, and can't a White Knight turn into a Black Knight?
Well, I think that's exactly the concern with White Knights. It's an interesting question, the White Knight, because one quite often sees in the context of a takeover offer that the investment bankers who are advising the target company will, whether the offer is friendly or otherwise, do their very best to find someone who might be able to put some competitive tension into the process. And indeed, our takeover rules have now changed so that target company can't agree to sign to any non-solicitation agreements in the way that it used to prior to 2012. So the first thing as a bidder in a friendly scenario you would do is make sure that you had a non-solicitation undertaking signed up to stop those investment bankers trying to create a higher price. That regime has now disappeared, and it's definitely the case in friendly scenarios that sort of behaviour goes on. A genuine white knight scenario, we see them talked about regularly, and one of the things I'll come on to mention in the context of the Cadbury deal is two potential white knights that appeared on the horizon there. Perhaps more common are the white squire tactics, which is a term that certainly to me means rather than finding an alternative bidder for the company, finding someone who can take a blocking stake in the company. And we saw that, I think, in 2008 when Rio Tinto was on the receiving end of a hostile approach, and Chinalco and Alcoa went into the market, partly to protect their own interests, but which were aligned with the independence of Rio Tinto, and bought a 12% blocking stake, which meant that the bid was doomed to fail from the start. So those tactics are prevalent, but as you say, beware that today's white squire could be next year's hostile suitor.
Martin, any examples on the German market where we saw a white knight in the past?
There's several famous ones where it actually did work. The thing is with the white knights, you often don't hear about them because they're considering to be a white knight, and then in the end they're backing out. Again, a timing issue. If you're not prepared, and this is what Yuri pointed out earlier, if you don't have a certain level of preparation to launch a bid, to get your financing in place, to get your board approvals, it's really hard. But we've seen the takeover from Vella, where Henkel and Procter & Gamble competed. Procter & Gamble actually was considered not necessarily a white knight by the board, but they in the end followed through, and we've seen it in Schering and Merck. So there have been examples, yes, but not too many.
But at least some of them are successful. So, and if I understand it correct, Phil, this is more or less the only chance that the board in the UK has to find someone who is more suitable to its interests.
Yes.
Okay, we'd like to proceed now with case study number 3. And Phil, this is your turn again, and tell us more about Cadbury and Kraft Foods.
Sure. Well, if you like, this is two case studies within one, because it tells the story of two unsolicited situations, but one of which, the approach by Kraft Foods for Cadbury in 2009, was if you like, controversial and had such a political element to it that it's led to a change in our takeover rules to redress certain imbalances. And I think that plays out in a subsequent takeover approach, the Pfizer approach for AstraZeneca that we've seen earlier this year, which may still come back, but at the moment has died. But broadly, Kraft approached Cadbury in 2009, and the English were very, very upset that the Americans might change the recipe for our chocolate, and this caused a great deal of social and political uproar. There was a hotly contested takeover battle at the time, which followed what had become, if you like, the normal path for these transactions, where the bidder would approach the target with an offer. The offer would be rejected by the target company, and so the bidder would find a means as quickly as possible to make sure that the details of its offer became public. And the reason for doing that was to enable them to be free then of their obligations of confidentiality under our takeover rules, which then in turn freed them up to start a public campaign, but particularly to approach institutional shareholders in the target company to sell the merits of the offer and persuade them to get behind the bidder, to put pressure on the target board and get them to a recommendation. And this became, if you like, the dance that you would do for unsolicited takeovers in the UK for a number of years. and it became colloquially referred to as a bear hug. You'll hear bear hugs talked about, and we still have bear hugs, but they're less persuasive than they used to be. There was a perception on the back of that transaction that there was an imbalance between the powers of the target company and the bidder. The bidder held all the cards in this ritual dance of a bear hug. And so our takeover rules were changed to give some of those cards back to the target company. And they were changed in a number of reasonably fundamental ways. Perhaps the most fundamental related to the put up or shut up regime that we've talked about in relation to other contexts. Historically, before the rule changes, once an approach has been made and a target company was under siege, it had to proactively approach the regulator in the UK, the Takeover panel, to persuade it to issue a put up or shut up notice, which would require the bidder to make a firm, fully financed, definitive offer to its shareholders within a specified period, normally around 6 or 7 weeks, or to announce that it wasn't going to proceed with an offer and then walk away when it was then shut out for a 6-month period. But the period we would see before a target company could successfully talk to the regulator to get a put up or shut up notice was generally pretty long. It was 5 or 6 weeks in itself. It would then spend a week or so persuading the regulator that it was under siege, management time was distracted, there was uncertainty in the share price, the shareholders shares were changing hands as short-term investors were coming in speculating on the outcome of the offer, and that because the offer was undervaluing the company, it needed certainty and it needed a put up or shut up notice to be given. So the primary change in the rules in 2012 was to say that as soon as the offer becomes public, or the interest in an offer becomes public, so if there's a leak or an announcement is made that one of the parties is in talks or considering an offer, then from that moment in time, we have a mandatory 28-day period for a put up or shut up. So the bidder then has an awful lot of pressure in an unsolicited situation to finance its offer, complete the terms, and launch the offer. And that is meant to be an antidote, if you like, to the bear hug. A few other things changed, increased disclosure requirements, and in particular, a ban on deal protection measures, which again de-risk a transaction from the bidder's perspective. So I mentioned non-solicitation agreements earlier on, break fees, all of these measures that were becoming very much a market standard but were not really strictly necessary to encourage a bidder to proceed. If you like, they were market practices that were imported from the States. So what's that meant in practice? Well, I think the two stories of Cadbury Kraft and Pfizer AstraZeneca give a reasonable illustration. To briefly step through the timeline on the Cadbury transaction, on the 28th of August 2009, there was an informal chairman-to-chairman approach, which was dismissed by Cadbury as undervaluing Cadbury. At the beginning of September, a week or so later, Kraft went public with its interest and said what the level of its offer would be. And Cadbury very quickly rejected that approach publicly and waited for the next step. On the 21st of September, so 3.5 weeks after the initial approach, Cadbury went to the UK Takeover panel, the regulator, to say, we need you to issue a put up or shut up notice so we know where we are with Kraft. And if you can see from the timeline, that put up or shut up order took over a week to come, and the panel ruled that Kraft had until the 9th of November to put up or shut up. So that's effectively 6 weeks period to put up or shut up, but about 3 months from the approach, which in corporate life, when you're under siege as a public company, is a significant period. Cadbury did various things to try and persuade its shareholders that any approach from Kraft should be rejected. It posted more upbeat numbers, it talked about its future dividend prospects, but none of the sort of frustrating actions that we've talked about in the past. On the 9th of November 2009, Kraft announced a formal takeover offer, which is effectively the point of no return. So a fully financed definitive takeover offer that was a genuine hostile offer. There was no recommendation from the board of Cadbury, but because of the pressure the put up or shut up had put on Kraft, they'd gone right to the end of that period and they pulled the trigger and launched their hostile offer. Interestingly, at this point, Cadbury started telling the market that two potential white knights were also looking at the investment in the shape of Hershey and Ferrero, and made and actually both of those companies announced that they were considering doing it. So just trying to keep the Cadbury shareholders calm until they saw whether there was a basis to become involved. Kraft eventually posted its formal offer documentation on the 4th of December. And again, Cadbury continued to defend, promising bigger dividends and strong growth, and just reminding its shareholders that Hershey and Ferrero were still out there. Eventually, Kraft, having played with the blend of consideration, the proportions of the cash and shares in its offer, it eventually, on the 19th of January, increased its offer. And as a result of that and significant pressure that it had managed to bring to bear on the Cadbury board through institutional shareholders, received a recommendation. So even this transaction, which started as a bear hug, became a hostile offer, ultimately ended up being a recommended offer. And it was simply a function of the amount of time that Kraft had to work on the institutions, to finalise its offer, to get the financing firepower that would enable it to do this. And there was a perception not only that that was an improper balance, that it had so long to do so, but also there was then some social consequences when Kraft, having said it wouldn't do so, closed a number of factories in the UK, which caused a political intervention and led to a rule change. Fast forward to this year, and we have Pfizer's approach to AstraZeneca, which the dynamics from the start looked broadly comparable, but actually it played itself out in a different way. So at the end of last year in November, Pfizer made a private approach to AstraZeneca. In January, it made its first offer, again all private, which was rejected. And Pfizer told AstraZeneca at that point that it was no longer interested in pursuing an offer. But it only said so privately, which means it wasn't precluded from coming back and making another offer. In April of this year, there was rumour and speculation in the market that Pfizer had actually made an approach previously and was now considering doing so again. And as is the way under our rules, where you have that type of speculation, an announcement is required to avoid a false market being created in any stock. The Pfizer chairman wanted to issue a joint statement with AstraZeneca to say, yes, we're in talks about a merger. But AstraZeneca rejected that suggestion, saying we need a firm offer before we can go public as being in discussions with you. So on the 28th of April, Pfizer did what it's required to do under our rules, which is to state publicly that it's considering making an offer, but that an offer may or may not actually happen. And as soon as that announcement went out, that possible offer announcement, that triggers the new mandatory 28-day put-up or shut-up period. So at that point, Pfizer had until the 26th of May to launch a fully financed offer, either with or without a recommendation from AstraZeneca. The time drew on, and Pfizer put out a couple of announcements trying to persuade shareholders of AstraZeneca of the merits of a bid. AstraZeneca put out various announcements of its own, telling its shareholders why a bid undervalued the company. And after one or two enhancements to the offer, on 19th of May, AstraZeneca made what it described as a final proposal that it wouldn't increase, or rather said that those would be the terms of its proposal. And again, that was rejected by AstraZeneca. And on 26th of May, this put-up or shut-up period expired, and Pfizer had to announce that it was walking away. The speculation in the market is that it may be back in a few months' time, but at the moment it's shut out for a minimum of 3 months, probably 6 months. And the real difference there was simply that Pfizer didn't have the opportunity to spend as much time as Kraft had in the Cadbury context, canvassing the institutional shareholders in AstraZeneca. It was also very distracted because there was a significant political reaction to the approach, largely as a result of people being concerned it was a replay of the Cadbury transaction. And so the management of Pfizer were called into parliamentary select committees to justify what they would do with the business going forward. Interestingly, the English government has no power to intervene in that scenario, but they wasted a huge amount of Pfizer's time in this short 28-day period by hauling them into meetings in the Commons to justify themselves and to get commitments from them that would be moral rather than legal. But I think it's an interesting example of the way that the balance has shifted a little bit more in favour of the target company. And it's also a good illustration of the types of defensive measures that typically are employed in the UK. And they really are less significant than some of those that we've been talking about. Communication is absolutely key. And there is a PR battle that wages from very early on. And the key components of the PR battle from the target's perspective are the value of the transaction, potential future growth and value in the business, the prospects for employees and the business going forwards, and generally the social commitments that the bidder is prepared to make. And those tend to be the focuses, along with quite regularly undertakings as to the extent that it will pay dividends or return cash to shareholders in the future, assuming that the bid fails. So I think that was the comparison I wanted to draw.
Thanks, Phil. What I don't understand is why didn't Pfizer simply make a bid and then tested it on the institutional investors, even without the recommendation of the board?
Oh, well, I think that's a very good question, and that's what we were, some of us were waiting to see. I think the rejections that they had received were so concrete at the prices they were prepared to pay. Interestingly, they were also suffering themselves in the sense that their trading performance in the US had not been strong. So actually, rather than increasing the value of the offer, their share price was coming off, so the offer was actually becoming lower and therefore more expensive for them to raise it each time. And I think it just reached a point where, with those commercial dynamics plus the intervention, albeit without any real teeth from the government, they decided that it wasn't the right thing to do in that time period.
Okay, thanks. Martin, what kind of role does the recommendation of the board play on the German market and the German takeover law?
Legally speaking, not a big one. The board has the obligation to give a recommendation to the shareholders, but you know, the offer may or may not be successful no matter what the board says in that recommendation. In fact, this recommendation has always been very important because bidders want to have the board's recommendation because obviously shareholders will take a strong position with the board because the board knows best. And if they say we're not recommending this because we don't see the values right, then legally that does not have any implications, but factually it does. When I said it used to be that way, what I mean is, again, the trend to these low-ball offers where the board says the offer may strategically make sense, but the price is too low, and the bidder says, I don't care, because I only want to get the 30%, and from there on I do what I want to do and build my stake as I feel free to do that. So it kind of shifts. I think the recommendation is still very important, but it's not as important as it used to be, actually.
Natalia, when you are seeing a mandatory takeover offer in Russia, Is the board also required to make a recommendation then to the shareholders whether or not the board thinks this is an appropriate consideration?
Yes, so there is, whether that's a voluntary offer or mandatory tender offer, the board of the company, once the offer is received, is required within 15 days to give its recommendation on the price, general evaluation of the offer. Actually, there's no requirement to evaluate the price. So the board just has a say as to whether it recommends, not recommends the offer. And very often these recommendations are taken quite formally. So we've seen in many mandatory offers, the recommendation of the board will just repeat one another, some very vague formulations, just because the concept is new, and generally, as I said, very often does not really affect the way the offer proceeds. However, there are transactions where we've seen the board forming an independent committee, and that's some cases where the transaction is controversial in a sense when the majority shareholder is increasing its stake by way of an offer. And the board of directors would form a committee of independent directors, because that's allows the board to really evidence that the offer has been considered, that there is conflict of interest has been excluded, and also serves as protection for the other board members. The independent committee cannot itself recommend the board, they recommend the offer, so it reviews the terms of the offer and then submits its recommendations, its conclusions to the main board, which then issues the recommendation. And it does serve as a means to limit liability of directors, rather as a protection to the directors for directors' liability.
Yuri, does it happen in practice that the board then actually makes the recommendation not to accept a mandatory takeover offer?
Well, I personally didn't meet such cases, at least in Russia. Also, there were outside cases, but I think this is also partly because still, the current stage in the Russian economy, that in most cases these public companies are still controlled by one major group, and the board is just a reflection of the will, so to say, of this controlling group. And that's why there is no really, independent participation, participation of independent directors in the board, and whatever board decides is basically the will of the controlling shareholder.
Alad, going back to the Anti-Takeover Foundation, which is independent, can the Anti-Takeover Foundation have a different view than the management? So is it possible that the management recommends a bid while the Anti-Takeover Foundation actually rejects the bid, or the other way around?
In theory, yes, because the foundation has to form its own independent view on whether a particular offer is or is not in the interest of the company. But in practice, I don't expect you will ever see a situation where the foundation would have a difference of opinion with the board, in a sense that the board would actually want an offer and where the foundation would frustrate it. I mean, I can see a situation where the board sees an offer as unfriendly and where the foundation perhaps takes a more moderate view, or for other reasons thinks that it would be inappropriate to exercise the option. That I can see, because the board members of the foundation also are exposed to liability, of course, if they would act in a manner that could, considered to be an act of tort against third parties and not exempt from liability. So they will have to be quite careful in their own deliberations and make sure that they are not just, following basically the instructions of the company, because that would defeat, I think, the purpose of the effectivity of the arrangement.
Let's spend some time then on the scope of duty of neutrality. Phil, you mentioned this before, that something like this applies as soon as the bid is in the world. What does this actually mean? And does this also mean that the board would have to apply the rules of equal treatment and treat one bidder equally like the potential white knight as regards access to information and stuff like that?
Well, that's exactly the area where this duty of equality kicks in. So if you have a friendly bidder as your first bidder, and you open your books and give them detailed due diligence information, for example, to facilitate their bid, then if a less welcome bidder appears on the scene to try and trump them, you are required to give them access to the same information. And it's a slightly bizarre framework in the UK, because as the second unwelcome bidder, you can't come along and say, I want all the same information that the other guy got. You have to effectively, specifically identify the information that you want, and if it's been given to the first bidder, then you receive it. What that means in practice is when you're the unwelcome bidder, you write a 50-page due diligence request list and hope that anything interesting is covered in it and you're going to get the same information. Yeah. But yes, absolutely. It has to be a level playing field for bidders, and all shareholders have to be treated equally from the moment that a bid situation arises.
And how's this game played by the board then? Do they really comply with this rule?
Yeah, they do. They do. It's carefully monitored, and we see a number of appeals from unwelcome bidders who think that they haven't received all of the information that another bidder has received, and there will be a full inquiry by the regulator. So what tends to happen in practice is where the welcome bidder, who's the first mover, comes along and asks for information, a target company will be very reluctant to give very detailed information, and in particular commercially sensitive industry information they won't want to hand across, or they will only hand across very much at the very latest stages of the process, so that if there were to be a competitor who decides to launch an offer, an unwelcome competitor, then they wouldn't have access to material information. And of course, the other aspect of that is you want to make sure that your unwelcome bidder is really a potential bidder and not just a competitor who's aware of these rules and is on a fishing expedition to know more about you. And there are frequently appeals in relation to the application of those rules in that scenario as well.
So how's this in Germany, Martin? Does the duty of neutrality also oblige the board to treat all bidders equally?
No, it does not, actually. The board they're not duty to not to frustrate any offer applies to all bidders. So, but there is no duty to actually facilitate or help somebody with their offers. There is a duty to treat shareholders equally. So, if both bidders come as shareholders, and this is what they always do, they argue, you know, I want equal treatment as a shareholder, not so much as a bidder. But then you say we have good reasons not to treat you equally, because the exemption to the equal treatment rule is if you have a good business reason not to do it, for example, to pass out trade secrets to a competitor, once those are out, you have damage in the company. You can also treat your shareholders unequally. So we in Germany, we're not quite as strict as the UK rules are, which is criticized, by the way. But
yes, and I think, you know, it's fair to say the duty to assist bidders only applies where you're treating them equally. So it's perfectly open to say to any bidder that you're not welcoming, no, you can't have any diligence information, and no, we're not providing you with any assistance at all. It's only that second stage where you have two bidders that you need equality.
Alad, we touched this point before. What else can be done to turn a hostile bid into a friendly one? So I understand that most of the hostile attempts sooner or later end in a friendly approach then. What, in addition to increasing your consideration, can be done?
Well, in our situation, the discussions with a bidder often relate to what I already mentioned as the non-financial covenants, i.e. a bidder who wants to turn a hostile or a hostile approach into a more friendly situation would normally, you know, put cards on the table in that area. So he would propose to perhaps guarantee the employment of a specific number of employees for a specific number of years, or he would guarantee to endorse the company strategy, or he would guarantee to leave the board in place. I mean, all those kind of things, and the discussions often quite concentrate on this catalogue of issues, apart from price. Also because, as far as price is concerned, I think there's a view that ultimately there is another arbitrator to decide whether the price is right or not, namely the shareholders themselves. While the board, of course, has to look after the interests that are served by these non-financial covenants. And in practice, you always see in merger protocols that bidders accept to a certain degree restrictions, on how they can deal with the company after the offer has been completed.
So this actually means that the bidder would then do the PR campaign that Phil already mentioned before.
Yes.
And what role do the political institutions play in such a scenario? Maybe Natalia, how does this play out on the on the Russian market?
Well, maybe situation in Russia is slightly different because it doesn't really have to do with turning a hostile bid into friendly just because how takeovers are structured. However, state authorities do play an important role or can play an important role in how the process proceeds. And the reason for that being that in order to proceed, for example, with a mandatory tender offer following acquisition of an initial stake, the bidder would require to obtain anti-monopoly approval. And the joint stock companies law is silent or surprisingly on what happens if there is no approval and the stake which the acquirer seeks to acquire is greater than what is permitted under applicable law. There is a special exception for strategic acquisitions. So if it's a strategic company, then the bidder would only be allowed to acquire up to the percentage of shares that it can acquire without an approval. So if that's not a subsoil user, that's up to 50%. If that's a subsoil user, then 25%. However, there is no such exception for straightforward anti-monopoly approvals. And as a result, very often the companies would choose to obtain approval up front, so for the whole transaction, maybe up to 100%. And the trick here is that once an application is submitted to the Russian anti-monopoly authorities, almost everyone on the market is aware that most likely this information will get leaked, so will be in the press. And that potentially may have an effect on the price of the company, rumors about a potential acquisition, which may or may not result in frustration of the deal. So it depends on how the bidder is prepared, whether it's prepared for any price fluctuation. Sometimes the market does not react. Sometimes the company may react. Sometimes the price may go up, and ultimately the deal may or may not proceed. So yes, there are instances where state authorities can play a role, and it's not just strictly in refusing to approve a certain deal.
Martin, do we know any case on the German market where the public authorities actually pushed a bidder or even frustrated an offer so that in the end the bid didn't went through?
No, we do not up until today. Maybe we'll see something now. There has been sometimes pressure on the politicians to intervene, but unlike the French politicians, the German politicians really keep out of all these takeover questions. We have a provision in our German law that any acquisition of any company from a non-European Union acquirer can be made subject to governmental approval if the German core interests are at stake. But the German core interests have never been at stake, and we don't even know what that really is. We sold part of our submarine business to Arab investors, and they didn't look into that. So if they don't look into that, what are they going to look into? No, they're keeping out of these things usually. Now there's a current example we've discussed earlier with the sale of DEA to a Russian investor, which is now scrutinized. But I think this is more for other reasons.
Okay, we would like to finish this session with a brief outlook on the Russian market. Natalia, and please, Yuri, comment if you have anything in mind. Can you please tell us how the future will look like? Will we see more unsolicited bids, takeover bids also here in Russia?
So just let me start, and then Yuri, if you can step in. Well, generally the market in Russia has experienced some slowdown in recent years, and that relates both to public offers and private transactions due to general slowdown in M&A activity. In addition to that, some recent deals questioned sufficiency of current regulations. That's in a number of aspects, including acquisition of indirect control, whether that results or does not result in making a mandatory offer for the company. As I mentioned in the beginning, both Russian courts and regulators seek to introduce amendments to the takeover regime, which are broadly in line with one another. So basically seeking to ensure that the various situations of acquisitions of indirect control are covered. Preference shares are taken into account. So there are a number of measures that the government, the legislators plan to introduce to improve the current takeover regime. And given that the Russian public companies are in fact underpriced, significantly underpriced, so they perhaps have the lowest valuation in the world if you take on jurisdictional analysis, there is a high likelihood that the number of takeovers will increase as the economy starts coming up. So we may see further deals, including hostile, in the coming years, and hopefully the legislation will be up to date by the time they're made.
Yuri, any last words?
So if I may add, I also have positive impression about this segment of the market. We have in our mentality, the ability or interest to adventurous transactions, so to say, or adventurous actions. So definitely Russian businessmen will continue to explore possibilities for obtaining control in more civilized manner, including over public companies. And of course, the major factor to achieve that would be, I agree with Natalia, further development of stock market. And the more public companies we have, the more there will be instances where corporate control will be attractive for acquisition. And of course, this will push further development of legal framework. We already have a good base, but still it needs to be improved, but also of court practice. And recent court developments also give us certain hope, like for instance, Russian recent court practice on estimate of damages, which allows now, even when you cannot present to the judge a hardcore estimate of your damages, the judge still would have to assess what would be the damages. Plus also several concepts like fiduciary duties of the directors, which needs first to be developed. Certain economic factors, like for instance, the willingness of banks to finance acquisitions, including acquisitions of public companies, and development of private equity industry and increase of private equity firms in this market would also contribute to the development of this segment of the market. So this is, at least, to me, an optimistic scenario, and I hope next year, when we meet at this forum, there will be more examples which Natalia and me will be able to quote as public bids here in Russia.
Okay, I will be happy to take this up and then discuss the next year again where we are. So we have reached now the end of our session. Thanks a lot. Spasibo za vaše vнимание. We don't want to hold off you any longer from the late lunch that you will be having now, hopefully. Thanks a lot also to my speakers, and hope to see you again next year. Spasibo.